Hello, everyone, and welcome to our Political Law Review presentation. I'm Charmaine Graceron, part of the reporting team of Group 10. Joining me in this endeavor are my classmates, Ms. Alano, Mr. Mayo, Mr. Opendo, and Ms. Samonte. Let's begin with our first case, the case of Javier et al. Versus Cadiao et al. The facts of the case are as follows. For the years 2007 to 2010, one of the hearing respondents, Vice Governor Rodolfo Cadiao, was the presiding officer of the Sangguniang Panlalawigan of Antique. On the first regular session of the Sangguniang Panlalawigan, the Lakas CMD bloc was considered as the majority party. Among those who belonged to the said party were Javier, Piccio, Vice Governor Cadiao, and Sangguniang Panlalawigan member Juanitas. Piccio was designated as the majority floor leader. On the other hand, the Nationalist People's Coalition, or NPC, was considered as the minority party with four members, including the herein respondent Combong. However, another Sangguniang Panlalawigan member who won as an independent candidate allied with the NPC. Additionally, the Sangguniang Panlalawigan has three ex officio members. Thereafter, for personal reasons, Juanitas left the majority party and joined the NPC, which was then headed by Combong, and Vice Governor Cadiao followed suit. Realizing that the NPC had gained superiority in numbers, Combong proposed a resolution which sought to reorganize the standing committees of the Sangguniang Panlalawigan. The resolution was included as an urgent matter in the agenda of the Sangguniang Panlalawigan's fifth regular session. During the fifth regular session, all the Sangguniang Panlalawigans were in attendance. Amidst fiery arguments, the Combong resolution was approved with 7 voting in its favor and 6 against it. Consequently, Piccio was replaced by Juanitas as majority floor leader. Some of the Lakas CMD members were also divested of chairmanship or membership in the Sangguniang Panlalawigan standing committees. To challenge the legality of the passage of the Combong Resolution, the Lakas CMT bloc filed before the RTC a complaint for injunction with urgent prayer for the issuance of a temporary restraining order and/or preliminary injunction. They maintained that for having been considered as an urgent matter, the passage of the Combong Resolution required an affirmative vote of two-thirds of all the members present pursuant to the Section 62, Paragraph 2, Rule 16 of the Internal Rules of Procedures of the Sangguniang Panlalawigan. So, since all 14 members of the Sangguniang Panlalawigan were present during the deliberations, 9 affirmative votes were necessary. The Lakas CMD bloc also cited Article 107, Paragraph 3 of the Implementing Rules and Regulations of the Local Government Code and the legal opinions of the DILG to argue that at least 8 affirmative votes corresponding to a simple majority were needed to validly pass the Combong Resolution. All 14 members of the Sangguniang Panlalawigan, including the Vice Governor Cadiao as the presiding officer, were present during that session. That being the case, the simple majority was half of 14 plus 1. In their answer, the respondents contended that the RTC lacked jurisdiction over the complaint. Further, an injunctive relief can no longer be issued since the Sangguniang Panlalawigan's reorganization was already a consummated act. The respondents likewise insisted that the Combong resolution was legally approved and the Lakas AMD bloc had not suffered any grave or irreparable damage consequent to its passage. The RTC upheld the validity of the passage of the Combong resolution and dismissed the complaint of the Lakas CMD bloc. So the issue in this case is whether or not the Vice Governor as the presiding officer of the Sangguniang Panlalawigan should be counted in the determination of what number constitutes as the majority. The Supreme Court held that the entire membership must be taken into account in computing the quorum of the Sangguniang Panlalawigan. It can thus be concluded that the Vice Governor forms part of the composition of the Sangguniang Panlalawigan as its presiding officer and should be counted in the determination of the existence of a quorum. However, the nature of the position of the presiding officer as a component of the Sangguniang Panlalawigan is distinct from the other members comprising the said body. The Vice Governor, as presiding officer of the Sangguniang Panlalawigan, must not be counted in determining the required majority to uphold the legislative matter before the Sangguniang Panlalawigan. The vice governor is elected at large. He holds the mandate of the entire body politic of the entire province. In contrast, regular Sangguniang Panlalawigan members are elected by district. The regular Sangguniang Panlalawigan members hold the mandate of specific constituency, like their district constituency. On the other hand, the ex officio Sangguniang Panlalawigan members represent their respective groups. The vice governor does not enjoy full rights of participation in the floors of the Sangguniang Panlalawigan since he holds the mandate of the entire province. He does not represent any particular group. He ensures that the Sangguniang Panlalawigan conducts its business for the general welfare of the entire province. Logically, then, the vice governor should be the embodiment of impartiality. He does not take side or cast vote to every question put upon the body. He exercises his right to vote only in situation of deadlock or tie under Section 49 of the Local Government Code. In the instant petition, when the Combong resolution was deliberated upon, all 10 regular and 3 ex officio members plus the presiding officer were present. 7 members voted for, while 6 voted against the Combong resolution. There was no tie to break as the majority vote had already been obtained. To hold that the presiding officer should be counted in determining the required number of votes necessary to uphold a matter before the Sangguniang Panlalawigan shall be counterproductive. It would admit deadlock as ordinary incidents in the conduct of business of the Sangguniang Panlalawigan, which is, in effect, incapacitates the said body from addressing every issue laid before it. In the process, the Sangguniang Panlalawigan's responsiveness, effectivity, and accountability towards the affairs of the body politic would be diminished. Verily, the Vice Governor, as the Sangguniang Panlalawigan's presiding officer, should be counted for purposes of ascertaining the existence of a quorum, but not in the determination of the required votes necessary to uphold the matter before the Sangguniang Panlalawigan. Hence, the passage of the Combong Resolution is valid. For the second case, the case of Carpio-Morales versus Court of Appeals. So in this case, a complaint or affidavit was filed before the Office of the Ombudsman against Binay Jr. and other public officers and employees of the city government of Makati, accusing them of plunder and violation of Republic Act number 3019 in connection with the 5 phases of the procurement and construction of Makati City Hall parking building. The Ombudsman constituted a special panel of investigators to conduct a fact finding investigation, submit investigation report, and file a necessary complaint if warranted. So, pursuant to the Ombudsman directive, the first special panel filed a complaint against Vinay Jr. et al., charging them of 6 administrative cases for grave misconduct, serious dishonesty, and conduct prejudicial to the best interest of the service, and 6 criminal cases for violation of Section 3, Paragraph E of Republic Act number 3019, malversation of public funds, and falsification of public documents. As to Binay Jr. himself, the OMB complaint alleged that he was involved in anomalous activities attending the procurement and construction phases of the Makati Parking Building project, committed during his previous and present term as City Mayor of Makati. The Ombudsman then created the second special panel to conduct a preliminary investigation and administrative adjudication on the OMB case, says. Upon recommendation of the Ombudsman, this second special panel issued a preventive suspension order, placing Binay Jr. et al. Under a preventive suspension for not more than 6 months without pay during the pendency of the OMB cases. Binay Jr. then filed a petition for certiorari before the Court of Appeals, praying for a nullification of the preventive suspension order and a temporary restraining order and or writ of preliminary injunction to enjoin its implementation. He argued that he could not be held administratively liable for any anomalous activity attending any of the 5 phases of the Makati Parking Building project, since phases 1 and 2 were undertaken because before he was elected mayor of Makati in 2010, and phases 3 to 5 transpired during his first term, and that his re-election as a city mayor of Makati for the second term effectively condoned his administrative liability, therefore rendering the administrative cases against him moot and academic. The Court of Appeals then issued a resolution granting Binay Jr.'s prayer for a temporary restraining order, notwithstanding Vice Mayor Peña's assumption of duties as acting mayor that day. It applied the condonation doctrine, considering that if it were established that acts subject of the administrative cases against Binay Jr. were all committed during his prior term, his re-election meant that he can no longer be administratively charged. In her manifestation before the Court of Appeals, the Ombudsman countered that there was nothing for the temporary restraining order to restrain because the preventive suspension order had already been served and Peña Jr. sworn in when the Court of Appeals issued the temporary restraining order. Disagreeing with the Ombudsman, Binay Jr. then filed a petition for contempt against her and other government officials. The Court of Appeals consolidated the petition for contempt with a petition for certiorari before it and scheduled a hearing for oral arguments. Prior to the said oral arguments, the Ombudsman filed a petition for certiorari before the Supreme Court, assailing the Court of Appeals resolution which granted Binay Jr.'s prayer for temporary restraining order. During the pendency of the instant case, the Court of Appeals issued a writ of preliminary injunction which further enjoined the implementation of the preventive suspension order. In view of this issuance, the Ombudsman filed a supplemental petition before the Supreme Court. So the issues in this case are first, whether the Court of Appeals had a subject matter jurisdiction over the petition for certiorari filed by Binay Jr. Second is whether the Court of Appeals had a subject matter jurisdiction to issue a temporary restraining order and or writ of preliminary injunction enjoining the implementation of the preventive suspension order issued by the Ombudsman. And last is whether the Court of Appeals committed a grave abuse of discretion in issuing the temporary restraining order and or writ of preliminary injunction based on the condemnation doctrine. The resolution of the first two issues depended on the Supreme Court's interpretation of Section 14 of the Ombudsman Act. Invoking the independence of the Office of the Ombudsman under the Constitution, the Ombudsman claimed that the first paragraph of Section 14 prohibited the Court of Appeals from issuing an injunctive writ to enjoin her office's preventive suspension against Binay Jr. The exception to the no injunction policy is when there is a prima facie evidence that the subject matter of the investigation is outside the office's jurisdiction. The Office of the Ombudsman has disciplinary authority over all elective and appointive officials of the government and its subdivisions, instrumentalities, and agency, with the exception only of impeachable officers, members of the Congress, and judiciary. Nonetheless, the Office of the Ombudsman retains the power to investigate any serious misconduct in the office allegedly committed by officials removable by impeachment for the purpose of filing a verified complaint for impeachment if warranted. Note that the Ombudsman has a concurrent jurisdiction over certain administrative cases which are within the jurisdiction of the regular courts or administrative agencies, but it has a primary jurisdiction to investigate any act or omission of a public officer or employee who is under the jurisdiction of the Sandigan Bayan. So, while the Supreme Court agreed that the Office of the Ombudsman is independent, being a constitutionally created office and is protected from political harassment and pressure, the former declared that such independence did not insulate her office from judicial power constitutionally vested unto courts. From this analysis, the Supreme Court continued that the Ombudsman's stance with regard to the first paragraph of Section 14 was contrary to the powers of the Supreme Court under the Constitution. According to the Supreme Court, when the Congress passed the first paragraph of Section 14, it took away from the courts their power to issue a temporary restraining order and or writ of preliminary injunction to enjoin an investigation conducted by the Ombudsman and encroach upon the court's constitutional rulemaking authority. Resolving that one of the inherent powers of a court is its power to issue provisional injunctive reliefs, the Supreme Court declared that by the aforementioned provision, the Congress interfered with a provisional remedy that was created by the courts under its duly promulgated rules of procedure. Without its consent to the prescription, there stood to be a violation of separation of powers. It also diluted a court's ability to carry out its function, considering that cases can be mooted by supervening events absent injunctive reliefs. Thus, The Supreme Court found it proper to declare as ineffective the prohibition under the first paragraph of Section 14 of the Ombudsman Act, the same being an undue interference of Congress on procedural matters without the Supreme Court's consent. Based on the same grounds, the Supreme Court also invalidated second paragraph of Section 14. This provision banned the whole range of remedies against issuances of the Ombudsman, except a Rule 45 appeal to the Supreme Court on pure question of law. The Supreme Court adjudged that this provision increased the Supreme Court's appellate jurisdiction without its consent. Consequently, the Supreme Court ruled that the Court of Appeals had a subject matter jurisdiction over Binay Jr.'s petition for certiorari and its resultant injunctive reliefs against the Ombudsman's preventive suspension order. To reiterate, the third issue before the Supreme Court was whether the Court of Appeals committed grave abuse of discretion amounting to lack or excess of jurisdiction in issuing the temporary restraining order and writ of preliminary injunction based on the condonation doctrine. While the Supreme Court disagreed with the Ombudsman and agreed with the Court of Appeals that it was not precluded from considering the same, given that it was material to the propriety of provisional injunctive relief, the Supreme Court reviewed the basis of the doctrine, tracing it back to U.S. jurisprudence, and found that it was not uniformly applied across all state jurisdictions. In reviewing the applicability of this doctrine to our jurisdiction, the Supreme Court likewise considered the constitutional provision on public office, that public office is a public trust and the corollary requirement of accountability to the people at all times is inconsistent with the idea that an elective local official's administrative liability for a misconduct committed during a prior term can be wiped off by the fact that he was elected to a second term of office or even another elective post. The Supreme Court held that by merely following the settled precedents on condemnation doctrine, which at that time unwittingly remained a good law, it cannot be concluded that the Court of Appeals committed a grave abuse of discretion based on its legal attribution. Hence, the writ of preliminary injunction was correctly issued. The ensuing course of action should have been for the Court of Appeals to resolve the main petition for certiorari on the merits. However, considering that the Ombudsman had already found Binay Jr. administratively liable and imposed upon him a penalty of dismissal, which carries the accessory penalty of the perpetual disqualification, the Court of Appeals petition appears to have been mooted. So moving on to the next case is the case of Dator versus Carpio-Morales. This case stemmed from the complaint filed by Villasenor against the incumbent mayor of Lukban, Quezon, which is petitioner Dator, and Macandile for grave misconduct, grave abuse of authority, and nepotism. It was alleged that in his immediately preceding term, Dator hired his sister Macandile as chief administrative officer through a job order and designated her as a municipal administrator through a special order. There was no appointment paper that was submitted to the Sangguniang Bayan for the required confirmation pursuant to Section 443, Paragraph D of the Local Government Code. It was also alleged that Macandile lacked the qualification of a municipal administrator, and her job order stated that she is not related within the third degree of consanguinity or affinity to the hiring authority and or representative of the hiring agency, when in truth and in fact she is the sister of the Tor. In the joint counter affidavit of Dator and Macandile, they denied the charges and stated that Macandile was merely granted an authority to perform the duties and functions of an administrator in the exigency and best interest of public service. They also stated that Macandile's credential showed her competence as she worked as the head nurse in Ginebra San Miguel from 1994 to 2005. They further alleged that the position of municipal administrator did not exist in the municipality's plantilla of personnel. Hence, there was no appointment paper submitted to the Sangguniang Bayan for confirmation. They also countered that the position of municipal administrator is primarily confidential, non-career, and conterminous with the appointing authority, and that the job order was executed for payroll purposes only. They pointed out that complainant was a former mayor of Lokban, Quezon, and the said practice was done even during the complainant's administration. They submitted copies of the job order forms issued during the administration of the complainant, where a Dr. Palermo Salvacion was designated as a chief administrative officer from 2007 to 2010. So the ombudsman dismissed the charges against Mahandile but found the Tor administratively liable for simple misconduct, which was approved by Ombudsman Conchita Carpio-Morales. A motion for reconsideration was then filed by the Tor, and a supplement to the motion for reconsideration was likewise filed by the Tor's new counsel, reiterating, among others, that complainant Villacensor granted authority through similar job orders. It was also further pointed out that administrative case was extinguished by the re-election of the Tor in 2016 under the Aguinaldo or condonation doctrine, which was only abandoned in 2015 by the Supreme Court in the Ombudsman Carpio-Morales versus Court of Appeals et al. Case. So the issue in this case was whether the Aguinaldo doctrine, otherwise known as the condonation doctrine, still applies. The Supreme Court said that the condonation doctrine is not applicable in this case. To begin with, the concept of public office is a public trust, and the corollary requirement of accountability to the people at all times, as mandated under the 1987 Constitution, is plainly inconsistent with the idea that an elective official's administrative liability for a misconduct committed during a prior term can be wiped off by the fact that he was elected to a second term of office or even another elective post. Election is not a mode of condoning an administrative offense, and there is simply no constitutional or statutory basis in our jurisdiction to support the notion that an official elected for a different term is fully absolved of any administrative liability arising from an offense done during a prior term. That being said, the Supreme Court simply finds no legal authority to sustain the condonation doctrine in this jurisdiction. As can be seen from this discourse, it was a doctrine adopted from one class of US rulings way back in 1959 and thus out of touch from and now rendered obsolete by the current regime. In consequence, it is high time for the Supreme Court to abandon the condonation doctrine. This ruling, however, was explicit in its pronouncement that the abandonment of the doctrine of condonation is prospective in application. Hence, the same doctrine is still applicable in cases that transpired prior to the ruling of Carpio-Morales versus Court of Appeals and Binay Jr. Here, the case against the Tor was instituted on May 2, 2016, or after the ruling of the Supreme Court in the seminal case of Carpio-Morales versus Court of Appeals and Binay Jr. Clearly, then, the condonation principle is no longer applicable to him. With regard to the simple misconduct, the Supreme Court affirmed the decision of the Ombudsman. The court said that the Ombudsman was correct in ruling that the Tor's act of issuing the special order and job order that hired his sister, Macandile, as Chief Administrative Officer was irregular. A reading of the special order appointing Mahandile would reveal that she was to undertake the functions of a municipal administrator, and the exact same functions are indeed to be carried out by a municipal administrator as set out in Section 480 of the Local Government Code. As correctly noted by the Ombudsman, the position of municipal administrator is unique because while it is conterminous with the appointing authority and highly confidential in character, it is required that the appointee must meet the qualifications enumerated under Section 480. Further, apart from the requirements set out in Section 480, Section 443 of the Local Government Code also provides the process by which a municipal administrator ought to be appointed. It was admitted that there was no confirmation of the appointment of Macandile by the Sangguniang Bayan, precisely because there was no existing plantilla for the position of municipal administrator or chief administrative officer. The Civil Service Commission also came out with a CSC resolution, and Macandile's designation as Chief Administrative Officer was irregular as it was clear violation of the CSC resolution. Dator was thus properly held liable for simple misconduct. It should be noted that the TOR has shown that the previous local government administration had repeatedly appointed Dr. Salvacion as Chief Administrative Officer through job orders. The court therefore appreciate the mitigating circumstance of good faith in this case that the TOR alleged in the performance of his action. The same repeated appointment by Dr. Salvacion also negates the finding that the TOR's appointment of Macandile was tainted with malice. So the next case is the case of Adormeo versus Comelec. So in this case, petitioner Raimundo Adormeo and private respondent Ramon Y. Talaga Jr. were the only candidates who filed their certificates of candidacy for mayor of Lucena City in the May 14, 2001 election. Petitioner then filed a petition to disqualify Talaga from running for mayor for the May 14, 2001 elections on the ground that the latter was elected and had served as city mayor for 3 consecutive terms. First, in the May 1992 election where he served the full term. Second is the May 1995 election where he again served the full term. And third, in the recall election on May 12, 2000 where he served only the unexpired term of Tagaraw after having lost to Tagaraw on the 1998 election. The petitioner further contended that private respondent was disqualified to run for city mayor by reason of the three-term limit rule because the unexpired portion of the term of office he served after winning a recall election covering the period May 12, 2000 to June 30, 2001 is considered a full term. He said that to interpret otherwise, private respondent would be serving 4 consecutive terms of 10 years in violation of Section 8, Article 10 of 1987 Constitution and Section 43B of the Local Government Code. The private respondent in turn maintains that his service as city mayor of Lucena is not consecutive because he lost his bid for a secondary election in 1998 and between June 30, 1998 to May 12, 2000, during Tagaraw's incumbency, he was a private citizen. Thus, he had not been mayor for 3 consecutive terms. So the issue in this case is whether private respondent talaga is disqualified to run for mayor of Lucena City in the May 14, 2001 elections. So as held in the case of Lasanida versus Comelec, there are two conditions for the application of disqualification. First is that the official concerned has been elected for 3 consecutive terms in the same local government post, and second is that he has fully served 3 consecutive terms. The respondent was not elected for 3 consecutive terms in this case. For nearly 2 years, he was a private citizen. The continuity of his mayorship was disrupted by his defeat in the 1998 elections. Neither can respondents' victory in the recall election be deemed a violation of Section 8, Article 10 of the Constitution as voluntary renunciation, for clearly it was not. Hence, private respondent was not disqualified to run for mayor in the May 14, 2001 elections. So the last case that I will be reporting is the case of Socrates versus Comelec. So in this case, a preparatory recall assembly was convened to initiate the recall of Victorino Dennis Socrates, who assumed office as Puerto Princesa's mayor on June 30, 2001. The PRA then passed a recall resolution which declared its loss of confidence in Socrates and called for his recall. The PRA then requested the Comelec to schedule the recall election for mayor within 30 days from the receipt of the recall resolution. Socrates then filed with the Comelec a petition to nullify and deny due course the recall resolution. But the Comelec and Bank dismissed Socrates' petition and gave due course to the recall resolution and scheduled the recall election. It also prescribed the calendar of activities and periods of certain prohibited acts in connection with the recall election. Meanwhile, Hagedorn filed his certificate of candidacy for mayor in the recall election. Then several petitions were filed before the Comelec seeking to disqualify Hagedorn from running in the recall election and to cancel his certificate of candidacy on the ground that Hagedorn is disqualified from running for a fourth consecutive term, having been elected and having served as mayor of the city for three consecutive full terms immediately prior to the instant recall election for the same post. The Comelec's first division dismissed the petition for lack of merit. It declared that Hagedorn is qualified to run in the recall election. The Comelec also reset the earlier scheduled recall election, and the Comelec affirmed the resolution declaring Hagedorn is qualified to run in the recall election. Several petitions were then filed to the Supreme Court assailing the Comelec resolutions. The Supreme Court ordered the Comelec to desist from proclaiming any winning candidate in the recall election until further orders from the Supreme Court. Hagedorn garnered the highest number of votes in the recall election. He then filed a motion to lift the order restraining the Comelec from proclaiming the winning candidate and allow him to assume office to give effect to the will of the electorate. So the issues in this case are first, whether the COMELEC committed grave abuse of discretion in upholding the recall resolution and scheduling the recall election for mayor of Puerto Princesa. And second is whether Hagedorn is qualified to run for mayor in the recall election of Puerto Princesa. So on the first issue, the court ruled that the COMELEC did not commit grave abuse of discretion in upholding the validity of the recall resolution and in scheduling the recall election. Petitioner Socrates argued that the COMELEC committed grave abuse of discretion in upholding the recall resolution despite the absence of notice to 130 PRA members and the defective service of notice to the other PRA members. The COMELEC found that on various dates in the month of June 2002, the proponents for the recall of incumbent city mayor Victorino Dennis Socrates sent notices to the convening of the PRA to the members thereof pursuant to Section 70 of the Local Government Code. Likewise, a proof of service for each of said notices were attached to the petition. Notices were also posted in conspicuous places, particularly at the barangay hall, and the proponents also utilized the broadcast mass media in the dissemination of the convening of the PRA. The notices of the convening of the Puerto Princesas PRA were also sent to the 25 names of provincial elective officials, print and broadcast media practitioners, PNP officials, Comelec City, regional and national officials, and DILG officials. The city election officers of the Puerto Princesa City also certified that upon thorough and careful verification of the signatures appearing in the PRA resolution, the majority of all the members of the PRA concerned approved said resolution and that not a single member or signatory of the PRA complained or objected as to the veracity and authenticity of their signatures. The provincial election supervisor of Palawan in his endorsement also stated that upon his proper review, all documents submitted were found in order. The acting director 4 of Region 4 in his study submitted and recommended that the instant petition is sufficient in form and substance. The PRA was validly constituted and that the majority of all the members thereof approved the resolution calling for the recall of Mayor Victorino Dennis Socrates. Thus, the Supreme Court held that it is bound by the findings of the fact of the COMELEC on matters within its competence and expertise, unless the findings are patently erroneous. Hence, the COMELEC did not commit grave abuse of discretion in upholding the validity of the recall resolution and in scheduling the recall election. Socrates also claims that the PRA members had no authority to adopt the recall resolution because a majority of the PRA members were seeking a new electoral mandate in the barangay election. This argument deserves a scant consideration, considering that when the PRA members adopted the recall resolution, their terms of office had not yet expired. They were all de jure sangguniang barangay members with no legal disqualification to participate in the recall assembly under Section 70 of the Local Government Code. On the second issue of whether Hagedorn is qualified to run for mayor in the recall election of Puerto Princesa, the court mentioned the three-term limit rule for elective officials as found in Section 8, Article 10 of the Constitution. This three-term limit rule was reiterated in Section 43, Paragraph B of the Local Government Code. These constitutional and statutory provisions have two parts. The first part provides that an elective local official cannot serve for more than 3 consecutive terms. The clear intent is that only consecutive terms count in determining the three-term limit rule. The second part states that the voluntary renunciation of office for any length of time does not interrupt the continuity of service. The clear intent is that involuntary severance from office for any length of time interrupts continuity of service and prevents the service before and after the interruption from being joined together to form a continuous service or consecutive terms. After 3 consecutive terms, an elective local official cannot seek immediate re-election for a fourth term. The prohibited election refers to the next regular election for the same office following the end of the 3rd consecutive term. Any subsequent election, like a recall election, is no longer covered by the prohibition for 2 reasons. First, a subsequent election, like a recall election, is no longer an immediate re-election after 3 consecutive terms. Second, the intervening period constitutes an involuntary interruption in the continuity of service. What the Constitution prohibits is an immediate re-election for a fourth term following 3 consecutive terms. The Constitution, however, does not prohibit a subsequent re-election for a fourth term as long as the re-election is not an immediately after the end of the 3rd consecutive term. A recall midway in the term following the 3rd consecutive term is a subsequent election but not an immediate re-election after the 3rd term. Neither does the Constitution prohibit one barred from seeking immediate re-election to run in any other subsequent election involving the same term of office. What the Constitution prohibits is a consecutive fourth term. In this case, the Hagedorn, his candidacy in the recall election on September 24, 2002, is not an immediate re-election after his 3rd consecutive term, which ended on June 30, 2001. The immediate re-election that the Constitution barred Hagedorn from seeking referred to the regular elections in 2001. So that's all for my part. I will now give the floor to the next reporter, Ms. Alano.
Good day everyone. I will be reporting the last case under the topic of recall. This case is Mayor Ricardo Angubong versus Comelec and Bank and Attorney Aurora de Alban. The facts of the case are as follows. Petitioner won as the duly elected mayor of the municipality of Tamauini, Isabela in the local elections of 1995, and he garnered 55% of all the votes cast. On the other hand, private respondent Attorney de Alban was also a candidate in said elections. And because of this, private respondent filed with the local election registrar of Tamauini, Isabela a petition for recall against petitioner. Acting on the petition, Deputy Executive Director for Operations, Pio Jose Hoson, submitted to the Comelec and Bank a memorandum recommending approval of the petition for recall filed by private respondent and its signing by other qualified voters in order to garner at least 25% of the total number of registered voters as required by Section 69, Paragraph D of the Local Government Code of 1991. Subsequently, Public Respondent Comelec issued a resolution which first approved the petition for recall, filed and signed by only one registered voter, herein private respondent against petitioner. Second, set the further signing of said petition by the rest of the registered voters of Tamauini Isabela on November 9, 1996. And third, in case the said petition is signed by at least 25% of the total number of registered votes in Tamauini Isabela, schedule the recall election on December 2, 1996. Petitioner Mayor Angubong now attacks the aforementioned resolution as being unconstitutional and therefore invalid on two main grounds. First, that the resolution approved the petition for recall, albeit same was signed by just one person in violation of the statutory 25% minimum requirement as to the number of signatures supporting any petition for recall. And second, that the resolution scheduled the recall election within 1 year from May 12, 1997 barangay elections. In at least 3 urgent motions, private respondent has sought the lifting of the temporary restraining order issued last October 25, 1996 on two grounds. First, that the issue of the 1-year bar on recall elections has been resolved in the case of Paras versus Comelec. And second, that the procedure prescribed by Resolution Number 96-2951 involving petition signing upon initiation of even just one person is no different from that provided for in Comelec Resolution Number 2272, which was upheld as constitutional in the 1991 cases of Sanchez et al. Versus Comelec and Everdan versus Comelec. So now there are two issues in this case, which are as follows. First, whether or not the petition for recall should be prevented by the 1-year bar on recall elections. And second, whether or not the petition for recall violated the statutory 25% minimum requirement. As to the first issue, the Supreme Court ruled in the negative. The court held that private respondent is correct in saying that in the light of their pronouncement in Paras versus Comelec, the recall election scheduled on December 2, 1996 in the instant case cannot be said to be barred by the May 12, 1997 barangay elections. In construing the meaning of the term regular local election in Section 74 of the Local Government Code of 1991, which provides that no recall shall take place within 1 year immediately preceding a regular local election, the court ruled that for the time bar to apply, the approaching regular local election must be one where the position of the official to be recalled is to be actually contested and filled by the electorate. Thus, in the present case, where the time bar is being invoked by petitioner mayor in view of the approaching barangay elections in May 1997, there can be no application of the 1-year bar. Hence, no invalidity may be ascribed to Resolution Number 96-2951 on this ground. As to the second issue, the Supreme Court ruled in the positive. The court ruled that such petition for recall is violative of the 25% requirement since only one person filed the petition. Section 69, paragraph D of the Local Government Code of 1991 expressly provides that recall of any elective, among other things, municipal official may also be validly initiated upon petition of at least 25% of the total number of registered voters in the local government unit concerned during the election in which the local official sought to be recalled was elected. The law is plain and unequivocal as to what initiates recall proceedings. This means that only a petition of at least 25% of the total number of registered voters may validly initiate recall proceedings. The court take careful note of the phrase petition of at least 25% and point out that the law does not state that the petition must be signed by at least 25% of the registered voters. Rather, the petition must be of or by at least 25% of the registered voters. Hence, while the initiatory recall petition may not yet contain the signatures of at least 25% of the total number of registered voters, the petition must contain the names of at least 25% of the total number of registered voters in whose behalf only one person may sign the petition in the meantime. The court also said that they cannot sanction the procedure of the filing of the recall petition by a number of people less than the foregoing 25% statutory requirement, much less the filing thereof by just one person, as in the instant case, since this is indubitably violative of clear and categorical provisions of subsisting law. Our legislators did not peg the voter requirement at 25% out of caprice or in a vacuum. They knew that this is the requirement under a majority of the constitutions and recall statutes in various American states, to the same extent that they were aware of the rationale therefore. While recall was intended to be an effective and speedy remedy to remove an official who is not giving satisfaction to the electorate regardless of whether or not he is discharging his full duty to the best of his ability and his conscience dictates, it is a power granted to the people who, in concert, desire to change their leaders for a reason only they, as a collective, can justify. So in other words, recall must be pursued by the people, not just by one disgruntled loser in the elections or a small percentage of disenchanted electors. Otherwise, its purpose as a direct remedy of the people shall be defeated by the ill motives of a few among them, whose selfish resort to recall would destabilize the community and seriously disrupt the running of government. A scrutiny of the rationale underlying the time bar provisions and the percentage of minimum voter requirement in American recall statutes unmistakably reveals the vigilance of lawmakers against the abuse of power of recall. For instance, the Supreme Court of Illinois held in the case of In Re Bauer that the only logical reason which we can ascribe for requiring the electors to wait 1 year before petitioning for a recall election is to prevent premature action on their part in voting to remove a newly elected official before having had sufficient time to evaluate the soundness of his political policies and decisions. Along the same lines, the Supreme Court of Colorado held in the case of Brillantes versus City of Boulder that the framers, by requiring that a recall petition contain the signatures of at least 25% of all votes cast in the last election for all candidates for the position which the person sought to be recalled occupies, assured that a recall election will not be held in response to the wishes of a small and unrepresentative minority. However, once at least 25% of the electorate have expressed their dissatisfaction, the Constitution reserves the recall power to the will of the electorate. In the present case, private respondent proceeded to file the petition for recall with only herself as the filer and the initiator. She claims in her petition that she has, together with many others in Tamauini Isabela, lost confidence in the leadership of petitioner. But the petition does not bear the names of all these other citizens of Tamauini who have reportedly also become anxious to oust petitioner from the post of mayor. There is no doubt that private respondent is truly earnest in her cause, and the very fact that she affixed her name in the petition shows that she claims responsibility for the seeming affront to petitioner's continuance in office. But the same cannot be said of all the other people whom private respondent claims to have sentiments similar to her. To summarize the doctrine of this case, the power of recall, as the court defined, is a mode of removal of a public officer by the people before the end of his term of office. It has been held that to be indispensable for the proper administration of public affairs. Since the people have the sovereign power, not only do they have the power to elect a representative in the government, they also have the power to remove such officials if they are dissatisfied with the performances of the latter. Section 3, Article 10 of the 1987 Philippine Constitution also reiterates the mandate for Congress to enact a local government code which shall provide for a more responsive and accountable local government structure instituted through a system of decentralization with effective mechanisms of recall, initiative, and referendum. We now move forward to another topic, which is election laws. Under this topic, the first case is Brillantes versus Yorac. The facts of the case are as follows. So, petitioner is challenging the designation by the late President Corazon Aquino of the Philippines of Associate Commissioner Heidi Yorac as acting chairman of the Comelec, in place of Chairman Hilario Davide, who had been named chairman of the Fact-Finding Commission to investigate the December 1989 coup d'etat attempt. The qualifications of the respondent are conceded by the petitioner and are not an issue in this case. What is the issue is the power of the President of the Philippines to make the challenge designation in view of the status of the Commission on Elections as an independent constitutional body and the specific provision of Article 9C Section 1, Paragraph 2 of the Constitution, which states that in no case shall any member be appointed or designated in a temporary or acting capacity. The petitioner also invokes the case of Nacionalista Party versus Bautista, where President Elpidio Quirino designated the Solicitor General as acting member of the Comelec, and the court revoked the designation as contrary to the Constitution. It is also alleged that the respondent is not even the senior member of the Commission on Elections, being outranked by Associate Commissioner Alfredo E. Abueg Jr. Furthermore, petitioner contends that the choice of the acting chairman of the Comelec is an internal matter that should be resolved by the members themselves, and that the intrusion of the President of the Philippines violates their independence. He cites the practice in this court where the senior associate justice serves as acting Chief Justice in the absence of the Chief Justice. No designation from the President of the Philippines is necessary. The issue of the case is whether or not the designation made by the President violates the constitutional independence of the Commission on Elections. The Supreme Court ruled in the positive. Yorac's designation as acting chairman is unconstitutional. The court ruled that pursuant to Article 9-A, Section 1 of the Philippine Constitution, it expressly describes all the constitutional commissions as independent. Although essentially executive in nature, they are not under the control of the President of the Philippines in the discharge of their respective functions. Each of these commissions conducts its own proceedings under the applicable laws and its own rules and in the exercise of its own discretion. As provided for under Article 9-A, Section 7, its decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. The designation made by the President has dubious justification, as it was merely grounded on the quote administrative expediency to present the functions of a Comelec. In the choice of the acting chairman, the members of the Commission on Elections would most likely have been guided by the seniority rule, as they themselves would have appreciated it. In any event, that choice and the basis thereof were for them and not the President to make. To emphasize the importance of the Comelec's constitutionally guaranteed independence, the court said that the choice of a temporary chairman is an internal matter which comes under discretion of the Commission as a body, and that such discretion cannot be exercised for the Commission by anybody else. But even though the President's appointment of Yorac as acting President is void, the members of Comelec can choose to reinstate Yorac as their acting chairman. What is important is that the members should elect their acting chairman pursuant to the principles that constitutional commissions are guaranteed by the Constitution as an independent bodies. The Constitution provides for many safeguards to the independence of the Commission on Elections, foremost among which is the security of tenure of its members. That guarantee is not available to the respondent as acting chairman of the Comelec by designation of the President of the Philippines. We now go to the last case under the topic of election laws, which is Penera versus Comelec. Before we dive into this resolution case, let me give you a brief background about this Penera case. So, Penera and private respondent Edgar Andanar were mayoralty candidates in Santa Monica during the May 2007 elections. On April 2007, Andanar filed before the Office of the Regional Election Director, Caraga Region, a petition for disqualification against Penera, as well as the candidates for Vice Mayor and Sangguniang Bayan who belong to her political party. Andanar's claim is that they unlawfully engaged in election campaigning and partisan political activity prior to the commencement of the campaign period. Andanar contends that on 29th of March 2007, a day before the start of the authorized campaign period on March 30, 2007, Penera and her party mates went around via a motorcade in different barangays in Santa Monica, announcing their candidacies and requesting the people to vote for them on the day of the elections. On the other hand, Penera contends that the charge of premature campaigning was not true. Although Penera admitted that a motorcade did take place, she explained that it was simply in accordance with the usual practice in nearby cities and provinces where the filing of the certificates of candidacy was preceded by a motorcade which dispersed soon after the completion of such filing. In fact, Penera claimed in the motorcade held by her political party that no person made any speech, not even any of the candidates. Instead, there was only marching music in the background and a grandstanding for the purpose of raising the hands of the candidates in the motorcade. Finally, Penera cited Barroso versus Ampig in her defense, wherein the court supposedly ruled that a motorcade held by candidates during the filing of their COCs was not a form of a political campaigning. Now, the court granted Rosalinda Penera's motion for reconsideration. The assailed decision dismissed Penera's petition and affirmed the resolution of the Comelec as well as the resolution dated July 24, 2007 of the Comelec. The decision disqualified Penera from running for the office of mayor in Santa Monica, Surigao del Norte and declared that the vice mayor should succeed Penera. In support of her motion for reconsideration, Penera submits the following arguments. First, Penera was not yet a candidate at the time of the incident under Section 11 of Republic Act 8436 as amended by Section 13 of Republic Act 9369. Second, the petition for disqualification failed to submit convincing and substantial evidence against Penera for violation of Section 80 of the Omnibus Election Code. Third, Penera never admitted the allegations of the petition for disqualification and has consistently disputed the charge of premature campaigning. And lastly, the admission that Penera participated in a motorcade is not the same as admitting she engaged in premature election campaigning. The issue of the case is whether or not Penera was already a candidate to be liable for election offenses such as premature campaigning. The court ruled in the negative and ruled that Penera shall be the mayor of Santa Monica, Surigao del Norte, upholding the case of Lanot versus Comelec, which held that a person who files a certificate of candidacy is not a candidate until the start of the campaign period. In this case, the court explained the essential elements for violation of Section 80 of the Omnibus Election Code, which are as follows. First, a person engages in an election campaign or partisan political activity. Second, the act is designed to promote the election or defeat of a particular candidate or candidates. And lastly, the act is done outside the campaign period. The second element requires the existence of a candidate. Under Section 79, Paragraph A, a candidate is one who has filed a certificate of candidacy to an elective public office. Unless one has filed his certificate of candidacy, he is not a candidate. The third element requires that the campaign period has not started when the election campaign or partisan political activity is committed. Assuming that all candidates to a public office file their certificates of candidacy on the last day, which under Section 75 of the Omnibus Election Code is the day before the start of the campaign period, then no one can be prosecuted for violation of Section 80 for acts done prior to such last day. Before such last day, there is no particular candidate or candidates to campaign for or against. On the day immediately after the last day of filing, the campaign period starts and Section 80 ceases to apply since Section 80 covers only acts done outside the campaign period. Hence, if all candidates file their certificates of candidacy on the last day, Section 80 may only apply to acts done on such last day, which is before the start of the campaign period and after at least one candidate has filed his certificate of candidacy. This is perhaps the reason why those running for elective public office usually file their certificates of candidacy on the last day or close to the last day. The clear intention of Congress was to preserve the election periods as fixed by existing law prior to Republic Act 8436 and that one who fails to meet the early deadline will still not be considered as a candidate. A candidate is liable for an election offense only for acts done during the campaign period, not before. The law is clear as daylight. Any election offense that may be committed by a candidate under any election law cannot be committed before the start of the campaign period. in ruling that Penera is liable for premature campaigning for partisan political acts before the start of the campaigning, the assailed decision ignores the clear and express provision of the law. The plain meaning of this provision is that the effective date when partisan political acts become unlawful as a candidate is when the campaign period starts. Before the start of the campaign period, the same partisan political acts are lawful. Congress has laid down the law. A candidate is liable for election offenses only upon the start of the campaign period. The court has no power to ignore the clear and express mandate of the law that any person who files his COC within the filing period shall only be considered a candidate at the start of the campaign period for which he filed his certificate of candidacy. Neither can the court turn a blind eye to the express and clear language of the law that any unlawful act or omission applicable to a candidate shall take effect only upon the start of the campaign period. We now move forward to another topic, which is candidacies and eligibility of candidates. Under this topic, the first case is Agustin versus Comelec. The facts of the case are as follows. Sometime in 1997, petitioner Agustin was naturalized as a citizen of the United States of America. In 2012, he filed his COC for the position of mayor of the municipality of Marcos, Ilocos Norte, to be contested in the May 2013 local elections. He declared in his COC that he was a natural-born Filipino citizen and that he had been a resident of the municipality of Marcos, Ilocos Norte for 25 years. On the other hand, respondent Salvador Pilos, a rival mayoralty candidate, filed in the Comelec a petition to deny due course or to cancel the certificate of candidacy of Agustin, alleging that the petitioner had made a material misrepresentation in his COC by stating that he had been a resident of the municipality of Marcos for 25 years despite having registered as a voter therein only on May 31, 2012. In his answer, petitioner Agustin countered that the one-year requirement referred to residency, not to voter registration, that residency was not dependent on citizenship, such that his travel to Hawaii for business purposes did not violate the residency requirement pursuant to prevailing jurisprudence, and that as regards citizenship, he attached a copy of his affidavit of renunciation of United States American citizenship. The Commission on Elections, 2nd Division, issued its omnibus resolution holding that the requirement that a candidate must be a registered voter does not carry with it the requirement that he must be so 1 year before the elections because this refers to the residency qualification. As far as registration as a voter is concerned, it should suffice that they are duly registered upon the filing of their COCs or within the period prescribed by law for such registration. So then, Pilos moved for the reconsideration with the Comelec and back. Pilos alleged that the certification issued by the Bureau of Immigration reflected that the petitioner had voluntarily declared in his travel documents that he was a citizen of the United States of America, that when he traveled to Hawaii on October 6, 2012, he still used his USA passport despite his renunciation of his USA citizenship, and after filing his COC on October 2012, in which he declared that he was a resident of the municipality of Marcos, Ilocos Norte, and that the petitioner's declaration of his eligibility in his COC constituted material misrepresentation because of his failure to meet the citizenship and residency requirements. On April 23, 2013, the Commission on Elections and Bank issued its assailed resolution canceling and denying due course to the petitioner's certificate of candidacy, observing that while Agustin presented a copy of his affidavit of renunciation, he failed to furnish this commission a copy of his oath of allegiance. Noteworthy is the fact that in Agustin's affidavit of renunciation, it was stated that his oath of allegiance is attached. However, said attachment has not been made available for the perusal of this commission, having failed to sufficiently show that he complied with the provisions of Republic Act 9225. Agustin's certificate of candidacy must be cancelled or denied due course. On election day, the name of the petitioner remained in the ballot. He was later on proclaimed as the duly elected municipal mayor of Marcos, Ilocos Norte, the highest among the contending parties. The petitioner filed on an urgent motion to withdraw verified urgent motion for reconsideration with leave of court, the petitioner then instituted this case, alleging grave abuse of discretion amounting to lack or excess of jurisdiction on the part of Comelec and BAC. There are two issues in this case, which are as follows. First, whether or not Petitioner Agustin is eligible as a candidate for the position of Mayor of the Municipality of Marcos, Ilocos Norte. Second, whether or not Pilos claim that he is the rightful occupant of the contested elective position is correct. As to the first issue, the court ruled in the negative. Petitioner Agustin is not eligible as a candidate for the position of Mayor of the Municipality of Marcos, Ilocos Norte. The petitioner filed a valid certificate of candidacy, but the use of his United States of America passport after his renunciation of foreign citizenship rendered him disqualified from continuing as a mayoralty candidate. There are two remedies available under existing laws to prevent a candidate from running in an electoral race. One is by petition for disqualification, and the other by petition to deny due course to or to cancel his certificate of candidacy. While a person who is disqualified under Section 68 is merely prohibited to continue as a candidate, the person whose certificate is cancelled or denied due course under Section 78 is not treated as a candidate at all, as if he or she never filed a COC. The court upheld the declaration by the Commission on Elections and Bank that the petitioner was ineligible to run and be voted for as mayor of the municipality of Marcos, Ilocos Norte. It is not disputed that on October 6, 2012, after having renounced his USA citizenship and having already filed his certificate of candidacy, he traveled abroad using his USA passport, thereby representing himself as a citizen of the United States of America. He continued using his USA passport in his subsequent travels abroad despite having been already issued his Philippine passport on August 23, 2012. He thereby effectively repudiated his oath of renunciation on October 6, 2012, the first time he used his USA passport after renouncing his USA citizenship on October 2, 2012. Consequently, he could be considered an exclusively Filipino citizen only for the 4 days from October 2, 2012 until October 6, 2012. As to the second issue, the court ruled in the affirmative. Pilos' claim that he is the rightful occupant of the contested elective position is correct. Petitioner was declared disqualified by final judgment before election day. Hence, the votes cast for him should not be counted. His rival, respondent Pilos, should be proclaimed duly elected mayor for obtaining the highest number of votes in the elections. The effect of the petitioner's disqualification under the April 23, 2013 resolution depended on when the disqualification attained finality. The distinction exists because of Section 6 of Republic Act No. 6646, also known as the Electoral Reforms Law of 1987. Section 6 of the said law covers two situations. The first is when the disqualification becomes final before the elections, which is the situation covered in the first sentence of Section 6. The second is when the disqualification becomes final after the elections, which is the situation covered in the second sentence of Section 6. The present case falls under the first situation. Section 6 of the Electoral Reforms Law governing the first situation is categorical. A candidate disqualified by final judgment before an election cannot be voted for, and votes cast for him shall not be counted. The effect was to render the votes cast in his favor straight, resulting in Pilos being proclaimed the winning candidate.
Now going to the case of Silverio Tagolino versus House of Representatives. On November 30, 2009, Richard Gomez filed his certificate of candidacy as representative for the 4th Legislative District of Leyte under the ticket of the Liberal Party. Buenaventura Contilla, an opposing candidate, filed the verified petition, alleging that Richard was actually a resident of Colgate Street, East Vinil, San Juan City, Metro Manila, misrepresented in his COC that he resided in 910 Carlota Hills, Canadiang, Ormoc City. In this regard, Contilla asserted that Richard availed and failed to meet one-year residency requirement under Section 6, Article 6 of the 1987 Constitution, and thus should be declared disqualified, ineligible to run for the said office. In addition, Contilla prayed that Richard's COC be denied due course and or cancelled. The Comelec First Division disqualified Richard Gomez. The Comelec en banc denied the motion for reconsideration. On May 5, Lucy Marie Torres Gomez, private respondent, filed her COC together with a certificate of nomination and acceptance from the Liberal Party, endorsing her as the party's official substitute candidate of her husband, Richard Gomez. The Comelec en banc approved the substitution. During the elections, Richard, whose name remained on the ballots, garnered 101,250 votes, while his opposing candidate, Eufrancisco Cordelia Jr., current petitioner Silverio Tagolino, obtained 76,549 and 493 votes, respectively. In view of the aforementioned substitution, Lucy Torres was proclaimed the duly elected representative of the 4th District of Leyte. On May 24, 2010, petitioner filed a petition for co-warranto before the HRET in order to ask private respondent from her congressional seat, claiming that she did not validly substitute Richard as his COC was void ab initio, and the House of Representatives declared Lucy Torres as a qualified candidate. The issue of this case, whether or not the substitution made by Lucy Torres Gomez was valid. The court ruled in the negative. Lucy Torres Gomez did not validly substitute Richard Gomez. The court discussed that misrepresentation warrants cancellation of COC and not disqualification. When cancelled, there is no valid COC, and as such, there is no candidate. Ergo, there can't be substitution. Substitution is proper only when the substituted is disqualified, because he or she was considered a candidate until ordered discontinued. The court discussed also the distinction between disqualification and cancellation of COC. The Omnibus Election Code provides for certain remedies to assail a candidate's bid for public office. Among these, which obtain particular significance in this case, are 1. A petition for disqualification under Section 68, and 2. A petition to deny due course to and or cancel a certificate of candidacy under Section 78. The distinctions between the two are well perceived. Primarily, a disqualification case under Section 68 of the OEC is hinged on either A. The candidate's possession of a permanent resident status in a foreign country, or B. His or her commission of certain acts of disqualification. Now, a denial of due course to and or cancellation of a COC proceeding under 78 of the OEC is premised on a person's misrepresentation of any of the material qualifications required for the elected office aspired for. It is not enough that the person lacks the relevant qualification. He or she must have also made a false representation of the same in the COC. As explained in the case of Miranda versus Abaya, a candidate who is disqualified under Section 68 can be validly substituted pursuant to Section 77 because he remains a candidate until disqualified. But a person whose COC has been denied due course to and or cancelled under Section 78 cannot be substituted because he is not considered a candidate. Stated differently, since there would be no candidate to speak of under a denial of due course to and or cancellation of a COC case, then there would be no candidate to be substituted. The same does not obtain, however, in a disqualification case since there remains to be a candidate to be substituted, although his or her candidacy is discontinued. On this note, it is equally revelatory that Section 77 expressly enumerates the instances where substitution is permissible. That is when an official candidate of a registered or accredited political party dies, withdraws, or disqualified for any cause. Noticeably, material misrepresentation case are not included in the said section, therefore, cannot be a valid basis to proceed with candidate substitution. Now let us go to the case of Zapanta Tagolino versus House of Representatives. Let us now go to the facts of the case. Alfred Zapanta filed his certificate of candidacy on October 16, 2015. Alfred, a nominee of political party Acción Democrático, was then an incumbent city councilor of the city district of Antipolo City. On December 14 of the same year, Alfred filed before the commission a verified petition to deny the due course and or to cancel certificate of candidacy of Reynaldo Z. Zapanta, a nuisance candidate. He alleged that Reynaldo indicated the name Alfred both as his nickname in his certificate of candidacy and his name in the official ballots. He claimed that Reynaldo never identified himself as Alfred to prove his allegations. Alfred attached a printed copy of Reynaldo's social media accounts, which showed that Reynaldo was using the name Ray Zapata. Alfred also attached screenshots of public conversations from the same social media accounts where different people pertained to the account holder as Ray. Alfred averred that Reynaldo's use of the name Alfred was designed to mislead the voters, to steal the votes intended for him. He contended that Reynaldo has bona fide intention to run for office and not only aims to cause confusion among the voters of Antipolo City and thus prevent the faithful determination of the true will of the electorate of Antipolo City. He prayed that Reynaldo be declared as a nuisance candidate and that Reynaldo's certificate of candidacy be cancelled. He further prayed that Reynaldo's name be excluded in the official ballots, and should his petition be decided after the election, that the votes Reynaldo would have received be counted in his favor. On January 13, 2016, Reynaldo filed his answer, praying that Alfred's nuisance petition be dismissed. He questioned the authenticity of the social media accounts presented by Alfred, arguing that the latter could not establish that they belonged to him. Commission's Second Division granted Alfred's petition. It found that Reynaldo's name, as it was be indicated in the official ballots, was confusingly similar to Alfred's name. Commission NBAC denied Reynaldo's motion for reconsideration for lack of merit. It held that since the name Alfred could not be directly connected to Reynaldo's name, Reynaldo should have presented sufficient evidence to establish his allegations. The issue, whether or not Public Respondent Commission on Election erred in declaring petitioner Reynaldo S. Zapanta as a nuisance candidate. The ruling. The court ruled in the negative. The only way to distinguish petitioner from private respondent is their number on the ballot and their affiliations. Other than that, a voter who wanted to vote for Alfred Zapanta but only knows the name Alfred or surname Zapanta would be confused on which oval to shade to reflect his or her choice. No other candidate for the position of city councilor has either the name Alfred or Zapanta. This court holds that petitioner was not able to sufficiently show that voters can clearly identify that his chosen nickname pertains only to him. The affidavits he presented are not enough to show that he had been using the name Alfred or that he is publicly known by that name. Petitioner failed to deny that he had no campaign materials using the same Alfred Zapanta's name or present evidence to the contrary. He merely banked on his membership in a political party to support his claim that he had a bona fide intention to run for office. Association to a political party per se does not necessarily equate to a candidate's bona fide intent. Instead, he or she must show that he or she is seriously in running for office. This court, however, further holds that public respondents' order of adding petitioners' votes to the private respondents' votes is not tainted with grave abuse of discretion. However, its ruling on this issue must be set aside. As a principle, a nuisance candidate is thus defined as one who, based on the attendant circumstances, has no bona fide intention to run for office, for which the certificate of candidacy has been filed. The rationale behind this prohibition against nuisance candidates and the disqualification of candidates who have not advanced a bona fide intention to run for office is easy to divine. The state has a compelling interest to ensure that its electoral exercises are rational, objective, and orderly. Now let's discuss the case of Santos versus Comelec. In this case, petitioner Edgar Santos and respondent Pedro Panulaya were both candidates for mayor of the municipality of Balingoan, Misamis Oriental in the May 14, 2001 elections. The Municipal Board of Canvassers proclaimed respondent Panulaya as the duly elected mayor. However, petitioner filed an election protest before the lower court. After trial and revision of the ballots, the trial court found that petitioner garnered 2,181 votes, while respondent received only 2,105 votes. Hence, it rendered judgment declaring and proclaiming petitioner as the duly elected municipal mayor and setting aside as null and void the proclamation of respondent made by the Municipal Board of Canvassers. Petitioner thereafter filed a motion for execution, pending appeal. Meanwhile, before the trial court could act on the petitioner's motion, respondent filed with the Comelec a petition for certiorari assailing the decision of the trial court. Likewise, respondent appealed the trial court's decision to the Comelec. The Comelec issued a writ of preliminary injunction, while effectively enjoined the trial court from acting on petitioner's motion for execution pending appeal. Subsequently, the Comelec dismissed the petitioner's petition for certiorari after finding the trial court did not commit grave abuse of discretion in rendering the same decision. Hence, it declared that the trial court to dispose all of the incidents in the election protest with dispatch. The trial court issued an order approving the motion for execution pending appeal and installing petitioner as the duly elected mayor. Meanwhile, respondent filed with the Comelec a motion for reconsideration of the dismissal of his petition in SPR number 20, 2002. After 5 days, On August 26, 2002, he filed a supplemental petition in SPR 2002. And barely after 2 days later, on August 28, and while his motion for reconsideration of supplemental petition in SPR number 20, 2002 were pending, respondent filed another petition with the Comelec. The petition contained the same prayer as that in the supplemental petition filed. Acting on the respondent's motion, the Comelec issued the assailant order directing the parties to maintain the status quo and enjoining petitioner from assuming the functions of mayor. The issue in this case is whether or not Comelec committed grave abuse of discretion in giving due course instead of dismissing outright the petition of the respondent, and that respondent was guilty of foreign shopping, and also that the Comelec erred in setting aside the trial court's order granting execution of its decision pending appeal. On January 4, 2016, Ira Lucas, another candidate for the position of mayor of Mabalacat City, filed a petition for cancellation of the COC and or disqualification of Morales for the mayoral position of Mabalacat City. Lucas alleged that Morales was already disqualified to run for mayor since he was elected and had served 3 consecutive terms prior to 2016 election. Lucas also alleged that the conversion of the municipality of Mabalacat into Mabalacat City did not interrupt Morales' service for the full term for which the latter was elected. Morales countered that the conversion of the municipality of Mabalacat into Mabalacat City interrupted his term. According to him, his term as mayor of Mabalacat City is not a continuation of his term as mayor of the municipality of Mabalacat. He also averred that since he was already assumed the office, disputes as to his COC became moot, and the proper remedy is to file a quo warranto proceeding. During the 2016 elections, Morales also was proclaimed as the elected city mayor. Crisostomo Garbo got the second highest number of votes for the position of city mayor, and herein, petitioner Christian Halili was proclaimed as the elected city vice mayor. Let us now proceed to the case of Halili versus Comelec. Here are the facts. Marino P. Morales was elected and serves as mayor of the municipality of Mabalacat, Pampanga from July 1, 2007 to June 30, 2010. He was elected again as mayor during the 2010 elections. During his second term in 2012, Congress passed Republic Act No. 1016-4, converting the municipality of Mabalacat into a component city, and a plebiscite was held. In the 2013 election, he ran again and was elected as mayor of the new Mabalacat City. On December 8, 2015, he filed his certificate of candidacy for the 2016 elections for the purpose of the position of mayor of Mabalacat City. On January 4, 2016, Ira Lucas, another candidate for the position of mayor of Mabalacat City, filed a petition for cancellation of the COC and or disqualification of Morales for the mayoral position of Mabalacat City. Lucas alleged that Morales was already disqualified to run for mayor since he was elected and had served 3 consecutive terms prior to 2016 election. Lucas also alleged that the conversion of the municipality of Mabalacat into Mabalacat City did not interrupt Morales' service for the full term for which the latter was elected. Morales countered that the conversion of the municipality of Mabalacat into Mabalacat City interrupted his term. According to him, his term as mayor of Mabalacat City is not a continuation of his term as mayor of the municipality of Mabalacat. He also averred that since he was already assumed the office, disputes as to his COC became moot, and the proper remedy is to file a quo warranto proceeding. During the 2016 elections, Morales also was proclaimed as the elected city mayor. Crisostomo Garbo got the second highest number of votes for the position of city mayor, and herein, petitioner Christian Halili was proclaimed as the elected city vice mayor.
The issue in this case is whether or not the conversion of the municipality of Mabalacat to Mabalacat City interrupted Morales' service for the full term for which he was elected. The ruling of the court. The court ruled in the negative. There are 2 conditions which must concur for the application of the disqualification of a candidate based on a violation of the 3-term limit rule. First, that the official concerned has been elected for 3 consecutive terms in the same local government post, and second, that he has fully served 3 consecutive terms. In the case of Latasa versus Comelec, the SC held that the conversion of a municipality into a city does not constitute an interruption of the incumbent officials' continuity of service. We held that to be considered as an interruption of service, the law contemplates a rest period during which the local elective official steps down from office and ceases to exercise power of authority over the inhabitants of the territorial jurisdiction of a particular local government. Applying the rules in La Tasa, the provisions of RA 1016-4 means that the delineation of the metes and bounds of Mabalacat City did not change even by inch, and the land area previously covered by the municipality of Mabalacat is now transferred to Mabalacat City. Morales was disqualified, therefore, from running as city mayor of Mabalacat City in 2016 election because it violates the three-term limit rule.
The next case is Morales versus Lucas et al. The facts of the case are as follows. Petitioner Marino P. Morales was elected and served as mayor of the municipality of Mabalacat, Pampanga from July 1, 2007 to June 30, 2010. He was elected again as mayor during the 2010 elections. During his second term, Congress passed Republic Act No. 10164, converting the municipality of Mabalacat into a component city. Thereafter, a plebiscite was held. In the 2013 elections, Morales ran again and was elected as mayor of the new Mabalacat City. On December 2015, Morales filed a certificate of candidacy for the 2016 elections for the position of mayor of Mabalacat City as substitute candidate for Wilfredo Feliciano of Acción Democrático Party. On January 2016, respondent Pyra Lucas, also a candidate for the position of mayor of Mabalacat City, filed a petition for cancellation of the COC and or disqualification of Morales for the mayoral position of Mabalacat City before the Comelec. Lucas alleged that Morales was disqualified to run for mayor since he was elected and had served 3 consecutive terms prior to the 2016 elections. Lucas also alleged that the conversion of the municipality of Mabalacat into Mabalacat City did not interrupt Morales' service for the full term for which he was elected. On January 2016, Morales filed his verified answer, alleging that Lucas' petition should be summarily dismissed for lack of certification against forum shopping, for being filed out of time, and for lack of jurisdiction and or cause of action. Morales claimed that his candidacy did not violate the 3-term limit rule because the conversion of the municipality of Mabalacat into Mabalacat City interrupted his term. According to him, his term as mayor of the Mabalacat City is not a continuation of his term as mayor of the municipality of Mabalacat. On May 2016, following the canvass of all election returns, the City Board of Canvassers of Mabalacat City proclaimed Morales as elected city mayor and petitioner Christian C. Halili as elected city vice mayor. Subsequently, respondent Crisostomo Garbo, another candidate for the position of mayor of Mabalacat City, filed a motion for leave to intervene and to admit attached petition in intervention, alleging that he was interested in the outcome of the case since he obtained the second highest number of votes, and he should be proclaimed as mayor of Mabalacat City should Morales' COC be cancelled. On June 2016, Halili also filed a verified motion for leave to intervene and admit attached answer in intervention, alleging that, as incumbent vice mayor of Mabalacat City, he should be proclaimed as mayor of Mabalacat City should Morales' COC be cancelled pursuant to the rule of succession under Section 44 of the Local Government Code. On December 2016, Morales filed an opposition to Garbo's petition in intervention and a comment to Halili's answer in intervention before the Comelec, alleging that both pleadings are premature. The Comelec First Division granted the petition, cancelled Morales' COC, and ordered the proclamation of the qualified mayoralty candidate with the next higher number of votes. On January 2017, the Comelec and Bank granted the motions for leave to intervene filed by Garbo and Halili. In a resolution, the Comelec and Bank denied the motion for reconsideration filed by Morales for lack of merit and affirmed the resolution of the Comelec First Division. The Comelec and Bank declared that Garbo, being the qualified mayoralty candidate with the highest number of votes, should be proclaimed. On June 2017, Lucas filed a motion for execution and a subsequent manifestation, alleging the finality of the Comelec and Bank resolution. The Comelec and Bank issued a writ of execution, hence the instant petition for review. The issues in this case are, first, whether or not Morales violated the 3-term limit rule, and second, whether or not the Comelec gravely abused its discretion amounting to lack or excess of jurisdiction in proclaiming Garbo as the duly elected mayor of Mabalacat City for being the qualified candidate with the highest number of votes. For the first issue, the court ruled in the affirmative. The Supreme Court held that the 3-term limit rule is embodied in Section 8, Article 10 of the 1987 Constitution, which states that the term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of the service for the full term for which he was elected. It is restated in Section 43 of the Local Government Code that no local elected official shall serve for more than 3 consecutive terms in the same position. Voluntary renunciation of the office for any length of time shall not be considered as an interruption in the continuity of service for the full term for which the elective official concerned was elected. The intention behind the 3-term limit rule is not only to abrogate the monopolization of political power and prevent elected officials from breeding proprietary interest in their position, but also to enhance the people's freedom of choice. There are 2 conditions which must concur for the application of the disqualification of a candidate based on a violation of the 3-term limit rule. First, the official concerned has been elected for 3 consecutive terms in the same local government post, and second, he has fully served 3 consecutive terms. In the present case, Morales admits that he has been elected and has served as mayor of Mabalacat, Pampanga for 3 consecutive terms. First, 2007 to 2010, second, 2010 to 2013, and third, 2013 to 2016. However, Morales insists that his second term as mayor of the municipality of Mabalacat was interrupted by the conversion of the municipality into a component city. Morales claims that the Mabalacat city is an entirely different political unit from the municipality of Mabalacat, having an increased territory, income, and population. Applying the court's ruling in Latasa, the provisions of RA 10164 mean that the delineation of the metes and bounds of Mabalacat city did not change even by an inch the land area previously covered by the municipality of Mabalacat. Consequently, the inhabitants are the same group of voters who elected Morales to be their mayor for 3 consecutive terms, and over whom he held power and authority as their mayor. Accordingly, Morales never ceased from acting and discharging his duties and responsibilities as chief executive of Mabalacat, despite the conversion of the municipality of Mabalacat into Mabalacat City. In insisting that Mabalacat City is an entirely different political unit as that of municipality of Mabalacat, due to an alleged increased territory, income, and population, Morales cites the second paragraph of Section 2, RA 10164, and presents a political boundary map. The court ruled that Morales failed to substantiate his claim that Mabalacat City is an entirely different political unit as that of municipality of Mabalacat. For the second issue, the court ruled in the negative. The Supreme Court held that the rule on succession under Section 44 of RA 7160, as espoused by Halili, would not apply if the permanent vacancy was caused by one whose COC was void ab initio. A person whose COC had been denied due course and or cancelled under Section 78 is deemed to have not been a candidate at all, because his COC is considered void ab initio and thus cannot give rise to a valid candidacy and necessarily to valid votes. In case of vacancies caused by those with void ab initio COCs, the person legally entitled to the vacant position would be the candidate who garnered the next highest number of votes among those eligible. In this case, it is Garbo who is legally entitled to the position of mayor, having garnered the highest number of votes among the eligible candidates. Thus, the Comelec correctly proclaimed Garbo as mayor of Mabalacat City. The next case is Cayat versus Comelec. Facts of the case are as follows. Father Nardo Cayat and Thomas Paliling are the only candidates for the mayoralty post in Buguias, Benguet in the May 2004 local elections. Cayat filed a certificate of candidacy on January 5, 2004. On January 26, 2004, Paliling filed a petition for disqualification against Cayat before the Comelec Regional Election Office in Baguio City on the ground of misrepresentation. Paliling argues that Cayat made misrepresentations and committed acts of perjury when he declared that he is eligible for the said office, while in truth and in fact, Cayat was convicted for the crime of forcible acts of lasciviousness. And at the time of filing a certificate of candidacy, Cayat is disqualified to said office as mayor as he is still serving his sentence and or disqualification was not yet removed or cured. Comelec granted the petition of Paliling and Cayat filed a motion for reconsideration. Cayat argued that the Comelec First Division resolution is void because the Comelec did not acquire jurisdiction over him. Cayat also argued that Section 5 of Comelec Resolution number 6452, allowing service of summons by telegram, is void. Such motion for reconsideration was denied because Cayat failed to pay the filing fee, and hence the resolution was declared final and executory. Despite the decision, Cayat was still proclaimed as the winner. Thus, Paliling filed a motion for execution of judgment. Comelec grants a motion for execution of judgment and annuls the proclamation of respondent Father Nardo V. Cayat. On November 12, 2004, the new Municipal Board of Canvassers executed the Comelec First Division's order and proclaimed Paliling as mayor of Buguias, Benguet. Paliling took his oath of office on the same day. Feliceo Bayaksan, elected vice mayor of Buguias, Benguet, filed his petition in intervention, and Bayaksan prayed that the proclamation be nullified and that he be declared as a rightful mayor of Bugias Benguet because of the doctrine of rejection of second placer. Hence the instant petition for review. The issue in this case is whether or not the rejection of second placer doctrine is applicable. The court ruled in the negative. The Supreme Court held that there is no doubt as to the propriety of Paliling's proclamation for two basic reasons. First, the Comelec First Division's resolution canceling Kayat's certificate of candidacy due to disqualification became final and executory when Kayat failed to pay the prescribed filing fee. Thus, Paliling was the only candidate for mayor of Bugias Benguet in the May 2004 elections. 23 days before election day, Kayat was already disqualified by final judgment to run for mayor in the May 2004 elections. As the only candidate, Paliling was not a second placer. On the contrary, Paliling was the sole and only placer, second to none. The doctrine on the rejection of the second placer, which triggers the rule of succession, does not apply in the present case because Paliling is not a second placer but the only placer. Consequently, Paliling's proclamation as mayor of Bugias Benguet is beyond question. Second, there are specific requirements for the application of the doctrine on the rejection of the second placer. The doctrine would apply in Bayaksan's favor, regardless of his intervention in the present case, if two conditions concur. First, the decision on Kayat's disqualification remained pending on election day, which is May 10, 2004, resulting in the presence of two mayoralty candidates for Bugias Benguet in the elections. And second, the decision on Kayat's disqualification became final only after the elections. The law expressly declares that a candidate disqualified by final judgment before an election cannot be voted for and votes cast for him shall not be counted. This is a mandatory provision of law. Section 6 of Republic Act No. 6646, the Electoral Reforms Law of 1987, states that any candidate who has been declared by final judgment to be disqualified shall not be voted for and the votes cast for him shall not be counted. The next case is Panlaki versus Comelec et al. The facts of the case are as follows. Nardo Velasco was born in Sasmuan to Filipino parents. He married Evelyn Castillo. In 1983, he moved to the United States, where he subsequently became a citizen. Upon Velasco's application for dual citizenship under Republic Act No. 9225, he took his oath of allegiance to the Republic of the Philippines and returned to the Philippines. Velasco applied for registration as a voter of Sasmuan, which application was denied by the Election Registration Board. He thus filed a petition for the inclusion of his name in the list of voters before the Municipal Trial Court of Sasmuan, which reversed the Election Registration Board's decision and ordered his inclusion in the list of voters of Sasmuan. On appeal, the Regional Trial Court reversed the Municipal Trial Court's decision, drawing Velasco to elevate the matter via Rule 42 to the Court of Appeals. In the meantime, Velasco filed his certificate of candidacy for mayor of Sasmuan. Mozart Panlaki, another candidate for the said position, filed before the Comelec a petition to deny due course to and or to cancel Velasco's COC based on gross material misrepresentation as to his residency and consequently his qualification to vote. In the electoral bout of May 2007, Velasco won in the elections. As the Comelec failed to resolve Panlaki's petition prior to the elections, Velasco took his oath of office and assumed the duties of the office. Finding material misrepresentation on the part of Velasco, the Comelec canceled his COC and nullified his proclamation. As such, Panlaki filed a motion for him to be proclaimed as mayor, but the Comelec en banc dismissed the motion on the ground the rule on succession does not operate in favor of Panlaki as the second placer, because Velasco was not disqualified by final judgment before election day. Comelec then ordered Velasco to vacate his mayoralty post for the incumbent vice mayor to assume office as mayor. Hence, the instant petition for review. The issues in this case are first, whether or not the Regional Trial Court's decision in the voters' inclusion proceedings must be considered as the final judgment of disqualification against Velasco, which decision was issued more than 2 months prior to the elections. The second issue in this case is whether or not it is proper for the Comelec to deny the proclamation of Panlaki as mayor. For the first issue, the court ruled in the negative. The Supreme Court held that in terms of purpose, voters' inclusion or exclusion and COC denial or cancellation are different proceedings. One refers to the application to be registered as a voter to be eligible to vote, while the other refers to the application to be a candidate. Because of their differing purposes, they also involve different issues and entail different reliefs, although the facts on which they rest may have commonalities where they may be said to converge or interface. Voters' inclusion or exclusion proceedings, on one hand, essentially involve the issue of whether a petitioner shall be included in or excluded from the list of voters based on the qualifications required by law and the facts presented to show the possession of these qualifications. On the other hand, COC denial or cancellation proceedings involve the issue of whether there is a false representation of a material fact. The false representation must necessarily pertain not to a mere innocuous mistake, but to a material fact or those that refer to a candidate's qualifications for elective office. Apart from the requirement of materiality, the false representation must consist of a deliberate attempt to mislead, misinform, or hide a fact which would otherwise render a candidate ineligible or otherwise stated, with the intention to deceive the electorate as to the would-be candidate's qualifications for public office. It is not within the province of the regional trial court in the voters' inclusion or exclusion proceedings to take cognizance of and determine the presence of a false representation of a material fact. It has no jurisdiction to try the issues of whether the misrepresentation relates to material fact and whether there was intention to deceive the electorate in terms of one's qualification for public office. The finding that Velasco was not qualified to vote due to lack of residency requirement does not translate into a finding of a deliberate attempt to mislead, misinform, or hide a fact which would otherwise render him ineligible. Assuming arguendo the plausibility of Panlaki's theory, the Comelec correctly observed that when the Regional Trial Court issued its March 1, 2007 decision, there was yet no certificate of candidacy to cancel because Velasco's certificate of candidacy was filed only on March 28, 2007. Indeed, not only would it be in excess of jurisdiction, but also beyond the realm of possibility for the Regional Trial Court to rule that there was deliberate concealment on the part of Velasco when he stated under oath in a certificate of candidacy that he is a registered voter of Sasmuan despite his knowledge of the Regional Trial Court decision, which was yet forthcoming. For the second issue, the court held in the affirmative. The Supreme Court held that it is proper for the Comelec to deny Panlaki's proclamation. Since Velasco's disqualification as a candidate had not become final before the elections, the Comelec properly applied the rule in succession. To simplistically assume that the second placer would have received the other votes would be to substitute our judgment for the mind of the voter. The second placer is just that, a second placer. He lost the elections. He was repudiated by either a majority or plurality of voters. He could not be considered the first among qualified candidates because in a field which excluded a disqualified candidate, the conditions would have substantially changed. To allow the defeated and repudiated candidate to take over the mayoralty despite his rejection by the electorate is to disenfranchise them through no fault on their part, and to undermine the importance and the meaning of democracy and the right of the people to elect officials of their choice. Theoretically, the second placer could receive just one vote. In such a case, it would be absurd to proclaim the total repudiated candidate as the voter's choice. The next case is Garcia versus Comelec et al. The facts of the case are as follows. Petitioner Maria Angela S. Garcia and Jose Payumo III were candidates for the mayoralty race of Dinalupihan, Bataan during the May 13, 2013 national and local elections. In the poll's conclusion, Garcia was proclaimed winner for having garnered 31,138 votes as against Payumo's 13,202. The Office of the Election Officer of Dinalupihan then released to Payumo a certified copy of the printed Certificate of Canvass of Votes and Proclamation, bearing May 15, 2013 as the date of proclamation of the winning mayoralty candidate. On May 27, 2013, Payumo lodged an election protest with the Regional Trial Court, citing the fraud and irregularities in all the clustered precincts of Dinalupihan, heightened by the PCOS machine's unreliability, casting doubt on the results of the counting and canvassing of votes. Payumo claimed that from May 15, 2013, the proclamation date appearing on the printed COCP, he had 10 days or until May 25, 2013, within which to challenge the election results. He added that since May 25, 2013 falls on a Saturday, he filed his protest on the immediately succeeding working day, which is Monday, May 27, 2013. Garcia belied the allegations of fraud and urgently moved for the dismissal of Payumo's protest. She claimed that she was proclaimed mayor on May 14, not May 15, 2013, as indicated in the Manual Certificate of Canvass of Votes and Proclamation issued by the Dinalupihan's MBOC. She thus argued that the election protest was filed beyond the mandatory 10-day reglementary period for filing an election protest, which, as she claimed in this case, lasted only until May 24, 2013, a Friday. The RTC dismissed Payumo's protest for being barred by the statute of limitations. Payumo appealed the dismissal with the Comelec. The Comelec First Division granted Payumo's appeal. Hence, the instant petition for review. The issue in this case is whether or not Payumo's election protest was filed out of time. The court ruled in the affirmative. The Supreme Court held that jurisprudence teaches the rule that prescribing the 10-day reglementary period is mandatory and jurisdictional, and that the filing of an election protest beyond the period deprives the court of jurisdiction over the protest. Violation of this rule should neither be taken lightly nor brushed aside as a mere procedural lapse that can be overlooked. The rule is not a mere technicality but an essential requirement, the non-compliance of which would oust the court of jurisdiction over the case. Aware of the repercussions that befall an election protest belatedly filed, the private parties herein advance two conflicting dates where the reglementary period should recon, but between the two proposed reconning date, May 14, 2013, as claimed by petitioner, appears to be the correct date of proclamation.
I am Vicente Romanque, May III, and I will be the next presenter. The next case is Lorenzo versus Comelec. The facts of the case are as follows. Sonia R. Lorenzo and Nestor B. Magno were rival candidates for the position of mayor in San Isidro, Nueva Ecija in the local elections of May 14, 2001. A resident of San Isidro, Carlos Montes, filed a petition with the Commission on Elections seeking the disqualification of Nestor B. Magno as a candidate due to his conviction for direct bribery with the Sandigan Bayan. On May 7, 2001, the Comelec 2nd Division issued a resolution disqualifying Magno, which was affirmed by the Comelec en banc on May 12, 2001. Lorenzo was then proclaimed as the mayor-elect of San Isidro on May 18, 2001. Magno later filed a petition for certiorari with the Supreme Court, challenging his disqualification by the Comelec. The Supreme Court reversed the Comelec disqualification of Magno, stating that he was not disqualified to run for mayor in the May 14, 2001 elections. The Comelec en banc thereafter issued a resolution dated May 13, 2003, wherein it ordered the creation of new boards of election inspectors for all precincts in the municipality of San Isidro for the purpose of counting the votes cast for Magno and preparing new election returns for submission to the Municipal Board of Canvassers of San Isidro, and constituted a new Municipal Board of Canvassers for the purpose of canvassing said election returns and submitting the results to the Comelec. Hence, this instant petition for certiorari and mandamos, assailing the validity of the resolution dated May 13 and the orders dated May 22 and June 10. The issue that was raised to the Supreme Court was whether or not the proper remedy for Magno was an election protest. In resolving, the Supreme Court said, as a general rule, the proper remedy after the proclamation of the winning candidate for the position contested would be to file a regular election protest or a petition for quo warranto. This rule, however, admits of exceptions. 1. Where the Board of Canvassers was improperly constituted. 2. Where quo warranto was not the proper remedy. 3. Where what was filed was not really a petition for quo warranto or an election protest, but a petition to annul the proclamation. 4. Where the filing of a quo warranto petition or an election protest was expressly made without prejudice to the pre-proclamation controversy or was made ad cautelum. And 5. Where the proclamation was null and void. This case falls squarely within the fifth exception to the general rule because the proclamation of Lorenzo as mayor of San Isidro was null and void. As of May 18, 2001, the date on which Lorenzo was proclaimed mayor-elect of San Isidro, the question as regards Magno's qualifications for said post was still pending and was raised as an issue before the Supreme Court. The question of Magno's qualifications for the office of mayor was not resolved until October 4, 2002, when the court expressly ruled that Magno was qualified for the said post. Since the question of Magno's eligibility for the position of mayor was still pending, the canvass which excluded Magno from the list of qualified candidates was an incomplete canvass, and Lorenzo's proclamation on the basis thereof was illegal. An incomplete canvass is illegal and cannot be the basis of a valid proclamation. Furthermore, the question of his qualification or disqualification for the position of mayor had not yet been settled as of the expiration of the 10-day reglementary period. As such, Magno was not yet eligible to file an election protest, and therefore, the fact that no such protest was filed should not be an impediment to his proclamation as mayor, if the results of the canvass of the new Municipal Board of Canvassers would show that he garnered the highest number of votes. This is why the case was therefore dismissed by the Supreme Court. The next case is Tugade versus Comelec. The facts of the case are as follows. Edward V. Tugade and Florencio P. Agustin were candidates for Punong Barangay in San Raimundo, Balungao, Pangasinan during the July 15, 2002 barangay elections. Tugade was proclaimed the elected Punong Barangay on July 16, 2002 with a 1-vote margin, 246 votes for Tugade and 245 for Agustin. Agustin filed an election protest specifically challenging the results in precinct number 60A, 60A1. The Municipal Trial Court created a revision committee and after recounting, declared Agustin the winner with 246 votes to Tugade's 242. Tugade appealed to the Comelec, which on October 25, 2005, declared a tie between Tugade and Agustin, both having 246 votes. Comelec ordered a drawing of lots to determine the winner, reversing the MTC's decision. Tugade filed a motion for reconsideration, which was denied by the Comelec on January 5, 2006. The issue that was raised to the Supreme Court was whether or not the Comelec's declaration of a tie and order for a drawing of lots was valid or constituted grave abuse of discretion. The issue was resolved by the Supreme Court by stating that here, petitioner is questioning respondent Comelec's conclusion that there is a tie between the two candidates. Definitely, this is a factual issue. Grave abuse of discretion is committed when an act is 1. Done contrary to the Constitution, the law, or jurisprudence, or 2. Executed whimsically or arbitrarily in a manner so patent and so gross as to amount to an evasion of a positive duty or a virtual refusal to perform the duty enjoined, as where the power is exercised in an arbitrary or despotic manner because of passion or personal hostility. An act of a court or tribunal may constitute grave abuse of discretion when the same is performed in a capricious or whimsical exercise of judgment amounting to lack of jurisdiction. Such is wanting in the present case. Moreover, it is relevant to state that the respondent Comelec en banc, in ordering the immediate implementation of the resolution issued by its second division for the drawing of lots of the herein parties, acted in accordance with Section 240 of the Batas Pambansa 881, otherwise known as the Omnibus Election Code of the Philippines. Section 240 states that whenever it shall appear from the canvass that two or more candidates have received an equal and highest number of votes, or in cases where two or more candidates are to be elected for the same position, and two or more candidates receive the same number of votes for the last place in the number of to be elected, the Board of Canvassers, after recording this fact in its minutes, shall by resolution, upon 5 days' notice to all the tied candidates, hold a special public meeting at which the Board of Canvassers shall proceed to do the drawing of lots of the candidates who have tied, and shall proclaim as elected the candidates who may be favored by luck, and the candidate so proclaimed shall have the right to assume office in the same manner as if he had been elected by plurality of vote. The Board of Canvassers shall forthwith make a certificate stating the name of the candidate who have been favored by luck, and this proclamation on the basis thereof. In this case, the petition is therefore dismissed. The next case is Office of the President versus Cataquiz. The facts of the case are as follows. Cataquiz became the general manager of the Laguna Lake Development Authority, or LLDA, on April 16, 2001. A majority of LLDA's management committee and rank-and-file employees submitted a petition to oust Cataquiz on the grounds of corruption and incompetence on April 1, 2003. DENR Secretary Elisea G. Gozun initiated a fact-finding inquiry into the allegations. A fact-finding report dated May 21, 2003 found evidence supporting charges against Cataquiz. DENR Secretary Gozun recommended to the President that Cataquiz be relieved and investigated by the Presidential Anti-Graft Commission, or PAGC. CELLDA, an LLDA employees union, expressed support for Cataquiz's ouster in a letter to President Gloria Macapagal Arroyo on June 6, 2003. CELLDA filed a formal complaint before PAGC, charging Cataquiz with various violations, including those under RA number 3019, EO number 292, and RA number 6713. PAGC recommended Cataquiz's dismissal from service on December 5, 2003. Cataquiz was replaced by Fatima A.S. Valdez on December 8, 2003. The Office of the President adopted PAGC's findings and dismissed him from service with accessory penalties. Cataquiz filed a motion for reconsideration and/or new trial on August 4, 2004. On February 10, 2005, the OP issued an amended resolution modifying the penalty due to Cataquiz's replacement. The Court of Appeals reversed the amended resolution stating that accessory penalties couldn't be imposed without the principal penalty. It found certain charges invalid. The Ombudsman recommended dismissing charges under RA number 3019 on November 30, 2004. The issues that were raised to the Supreme Court are as follows. 1. Whether or not findings of fact by the appellate court can be reviewed. 2. Whether or not the dismissal of the criminal case against the respondent bars the finding of administrative liability. And 3. Whether or not the respondent can be imposed with accessory penalties. In resolving the first issue, the court said that findings of fact of the appellate court can be reviewed. The court emphasized that, in general, only questions of law can be raised in a petition for review on certiorari under Rule 45. However, exceptions to this rule include instances of speculation, grave abuse of discretion, misapprehension of facts, conflicting findings, and when the appellate court goes beyond the issues. In this case, the Court of Appeals findings contradicted those of PAGC and DANR's investigating team. The CA dismissed PAGC's conclusions without proper analysis, claiming Cataquiz had authority for his actions. The court criticized this lack of comprehensive discussion, noting the CA's failure to comply with the constitutional mandate for decisions to clearly state facts and laws. The Commission found substantial evidence supporting PAGC's determination that catechists should be dismissed for prejudicial acts and undue advantage given to a private company. Highlighted violations included unauthorized transactions with fish pen operators, condoning penalties without board approval, dismissing a case without authority, improper consultancy contracts, and prejudicial transactions with fill tie fishing and trade company. The court rejected the CA's inadequate justification for absolving catechists, asserting that the findings of administrative agencies should be considered binding when supported by substantial evidence. With regard to the second issue, the court declared that the dismissal of the criminal case against respondent does not bar the finding of administrative liability. The court clarified that the dismissal of the criminal case against Katakiz by the ombudsman did not automatically absolve him of administrative liability. Katakiz argued that the dismissal constituted the law of the case, but the court rejected this claim. The dismissal referred only to criminal charges, not the administrative case at hand. The court emphasized that it is a basic rule in administrative law that public officials are under a threefold responsibility for a violation of their duty or for a wrongful act or omission, such that they may be held civilly, criminally, and administratively liable for the same act. The resolution of one case does not necessarily affect the others, and the ombudsman dismissal of the criminal case did not prevent administrative action against Katakiz. As for the third issue, the court resolves by stating that respondent can be imposed with the accessory penalties. Katakiz's removal from the office does not exempt him from administrative liability for actions during his tenure. Despite his removal, the President has the authority to impose administrative penalties, and the subsequent finding of guilt by the OP is considered valid. Katakiz's argument that removal makes the imposition of dismissal impossible is refuted. The case cites precedents where, despite the separation from government service, accessory penalties such as disqualification and forfeiture of benefits were imposed. Based on the foregoing, it is clear that the accessory penalties of disqualification from re-employment in public service and forfeiture of government retirement benefits can still be imposed on the respondent, notwithstanding the impossibility of effecting the principal penalty of dismissal because of his removal from office. The last case of our report is Bagawisan versus Office of the Ombudsman. Ramil A. Bagawisan, the chief of Hospital 1 at Cortes Municipal Hospital in Cortes, Surigao del Sur, faced allegations of nepotism. On May 26, 2011, he issued Office Memorandum Order Number 12, designating his wife, Nelita L. Bagawisan, as Administrative Officer and Liaison Officer alongside her role as Nutritionist Dietitian 1. Subsequently, on November 5, 2013, he issued Office Memorandum Order Number 28, appointing Nelita to the additional function of Internal Control Unit. An anonymous letter prompted the Office of the Ombudsman for Mindanao to file a complaint charging Bagawisan with nepotism violations, invoking Section 59 of the Executive Order Number 292 in conjunction with Section 67 and 10 of Chapter 8 and Chapter 10, Title 1A, Book 5. In his defense, Bagawisan argued that nepotism rules do not cover designations and asserted that he designated his wife to a non-plantilla position in good faith. He emphasized that Nelita received no extra compensation for these designations. The sole issue that was raised to the Supreme Court was whether or not the CA erred in upholding the Ombudsman's finding that petitioner is guilty of grave misconduct and in meting upon him the penalty of dismissal from service. The prohibitory norm against nepotism in the public service is set out in Section 59, Chapter 8, Title 1A, Book 5 of EO 292.31. Nepotism is defined therein as follows. All appointments in the national, provincial, city, and municipal governments or in any branch or instrumentality thereof, including government-owned or controlled corporations, made in favor of a relative of the appointing or recommending authority, or of the chief of the bureau or office, or of the person exercising immediate supervision over him are hereby prohibited. As used in this section, the word relative and members of the family referred to are those related within the third degree either of consanguinity or of affinity. The following are exempted from the operation of the rules on nepotism. A. Persons employed in a confidential capacity. B. Teachers. C. Physicians. And D. Members of the Armed Forces of the Philippines, provided, however, that in each particular instance, full report of such appointment shall be made to the Commission. Under the foregoing definition, one is guilty of nepotism if an appointment is issued in favor of a relative within the third civil degree of consanguinity or affinity of any of the following. A. Appointing authority. B. Recommending authority. C. Chief of the bureau or office. And D. Person exercising immediate supervision over the appointee. The court rejects the petitioner's attempt to distinguish between appointment and designation, stating that such a differentiation would undermine the comprehensive nature of the nepotism rule. It emphasizes that the prohibition covers all appointments and dismisses the petitioner's reliance on the non-existence of budgetary allocations for the designated positions. The court underscores that the nepotism rule does not require the existence of a government position in the plantilla of an organization for its application. It also dismisses the petitioner's argument that good faith and the absence of compensation should exempt him from guilt. It reiterates that the prohibition aims to ensure the objectivity of appointing authorities and emphasizes that the public policy embodied in Section 59 is fundamental and cannot be diluted by introducing qualifications or distinctions. In this case, there was a willful intent to violate the law or to disregard established rules, as petitioner knowingly appointed his wife Nelita as administrative officer and liaison officer, and to perform functions as internal control unit at the Cortes Municipal Hospital. Accordingly, since a government employee who is found guilty of grave misconduct may be dismissed from service even for the first offense under the revised rules on administrative cases in the civil service, the CA aptly meted the penalty of dismissal with accessory penalties to petitioner. Therefore, the petition in this case is denied. Thank you. That is all.